Imagine showing up to work on a Tuesday morning, getting called into HR, not for a raise, not for a performance review, and being handed a bill. A bill for money your employer paid you. Money you already spent. The HR manager slides a repayment agreement across the table, $8,700, 60 days. Sign here. The question that defines this case. When a corporation's own payroll system silently overpays an employee for 14 consecutive months, who really bears the cost of that failure? Here's the full story. Our subject, we'll call him Marcus, is an account manager at a mid-sized firm in Illinois. He's good at his job. About 14 months before this story begins, his role quietly expanded. He took on client payment coordination, cross-departmental project management, responsibilities that clearly stretched beyond his original job description. His direct manager acknowledged it, vaguely, in a team meeting. A compensation adjustment was mentioned. Nothing in writing, nothing formal. Just the kind of thing a manager says in passing, and an employee files away while continuing to work. Then the extra money started appearing. Every paycheck, an additional $440. It arrived consistently through the company's official payroll system, processed alongside his regular salary for 26 pay periods straight. Marcus connected the dots himself. Extra responsibilities, manager's mention of a compensation adjustment, now extra pay. It seemed to add up. He adjusted his life accordingly, paid down lingering debt, covered medical expenses that had been hanging over him, and traveled for the first time in years. A total of approximately $8,700 in additional income, received and spent over 14 months. Then HR called him in. The explanation was blunt. A payroll administrator had entered a recurring bonus code into the system, a code intended for a completely different employee in a completely different department. Nobody caught it, not the payroll team, not accounting, not the managers who signed off on monthly reports, not the annual audit. For 14 months, the error ran silently, processed automatically, paid out reliably. And now Marcus was holding the bill for all of it, full repayment, 60 days, $8,700. Let's sit with Marcus's perspective, because it carries real legal weight. He didn't receive cash in an envelope. He didn't find an error and stay quiet. He received money through the company's official, audited payroll system. That system is maintained by HR, reviewed by finance, and signed off by management. Marcus had every rational reason to trust it. In fact, questioning a recurring paycheck in his favor, with a manager who had already hinted at a raise, might have seemed paranoid. His reliance on those payments was not just understandable. In law, it has a specific name and specific protections. Now the company's side, and they have one. Under a foundational legal principle called unjust enrichment, no party should benefit at another's expense without a legal basis. The company paid Marcus money it never intended to pay. That money was never earned under any formal agreement. The fact that Marcus spent it doesn't erase the underlying obligation, it simply complicates recovery. From a purely legal standpoint, the company is not wrong to want its money back. Their position is defensible. The real question isn't whether a debt exists. It's how much of it Marcus is actually obligated to repay and on whose timeline. Here's the counterintuitive angle most people miss entirely. The 60-day repayment demand isn't just aggressive, it may actually be the company's weakest move. Because that urgency, that pressure, that take-it-or-leave-it timeline reveals something. They want Marcus to sign before he talks to an attorney. Because if he does talk to an attorney, he's going to learn about a legal doctrine that could significantly reduce what he owes. And here's the question I want you to sit with. If you received consistent official paychecks for over a year, adjusted your entire financial life around them, and then got handed a bill, what would you do? There's another layer here that demands attention. Marcus is now being told his salary will revert to his original contracted baseline. Fine, that's legally sound. But he is still performing the extra work, the client coordination, the project management, that his manager acknowledged warranted additional pay. The company is simultaneously demanding $8,700 while continuing to benefit from labor they've never formally compensated. That asymmetry isn't just frustrating. It's potentially actionable. Illinois wage law doesn't look kindly on employers who accept expanded work while refusing to formalize the compensation for it. And then there's the document Marcus hasn't signed. That unsigned repayment agreement sitting on the table may be the most important piece of paper in this entire case. The moment he signs it, he acknowledges the debt is written, the amount, the timeline, the terms. Every single one of those elements is negotiable right now. None of them are negotiable after. That instinct Marcus had, to pause and say, "I need time to think," that wasn't weakness. That was the most tactically correct thing he did in that entire meeting. Let's talk Illinois law, because it matters here. The Illinois Wage Payment and Collection Act governs how employers can recover wage overpayments. Unauthorized deductions from future paychecks require written employee authorization. A demand for a lump sum cash repayment operates as a civil debt claim, but even then, the employer must prove the overpayment and cannot use tactics that violate state wage protections. Illinois courts have not consistently ruled in favor of employers who aggressively pursue overpayment recovery without acknowledging their own role in creating the error. Then there's the doctrine of lashes, pronounced latches. Lashes penalizes unreasonable delay in asserting a legal claim. If a party sits on their rights for an extended period, allowing the other party to change their position in reasonable reliance on the status quo, a court can reduce or bar recovery entirely. 14 months is not a minor oversight. Marcus didn't conceal the income. He didn't manipulate the system. He received official paychecks and built a financial life around them. A judge examining this case would very likely ask, whose negligence made this loss possible in the first place? There's also the change of position defense, distinct from lashes and arguably more powerful here. This doctrine holds that if someone receives money in good faith and materially changes their financial position as a result, pays off debt, covers irreversible medical expenses, makes life decisions, full recovery may be inequitable. Marcus didn't just sit on the money, he used it. He eliminated liabilities. He covered healthcare. He made financial moves that cannot be undone. Courts applying this doctrine ask, is it fair to demand full repayment from someone who had no reason to doubt they'd earned it? So what are Marcus's actual tactical options? Step 1. Do not sign that agreement as written. Request an itemized breakdown of exactly how the $8,700 figure was calculated. Ask for documentation of the original payroll error, the date it was entered, who entered it, which employee it was intended for. Request any internal communications about when the error was discovered versus when Marcus was notified. All of this is discoverable information. Getting it now, before litigation, costs nothing. Losing it later, after you've signed away your rights, costs everything. Step 2. Negotiate the timeline aggressively. 60 days for $8,700 is financially punishing for virtually anyone who doesn't have that money liquid. But there is no Illinois statute mandating that window. Repayment agreements spread over 12, 18, even 24 months are standard in employment settlements. Marcus can counterpropose modest monthly deductions from future paychecks, and critically, he should insist the agreement includes language stating he disputes the underlying obligation and is settling without admission of liability. That language is not just procedural. It preserves his right to raise defenses if the company later acts in bad faith. Step 3. The extra work issue is a separate and parallel negotiation, and it has leverage. If Marcus is performing duties that exceed his contract, he has a legitimate claim for prospective compensation. An employment attorney might advise filing a wage complaint with the Illinois Department of Labor, not as retaliation, but as formal documentation that a genuine compensation dispute exists on both sides of this ledger. Suddenly, the company isn't just a creditor pursuing a debtor. They're also a potential defendant in their own wage claim. That changes the dynamic at the negotiating table completely. If this reaches civil litigation, and it might, if Marcus refuses to repay and the company escalates, the economics of that decision matter. Filing fees, attorney hours, discovery requests, depositions. For $8,700, companies typically calculate whether the cost of litigation exceeds the expected recovery, especially when the defendant has legally colorable defenses like lashes and change of position. Marcus's strongest card may not be a legal argument at all. It may simply be this: make recovery expensive enough that a negotiated settlement, with a long repayment timeline and acknowledgement of the extra work, becomes the obvious rational path. And here's the twist that almost nobody sees coming. The company's aggressive 60-day demand may have actually handed Marcus a procedural shield. Illinois courts have found that coercive repayment demands, particularly where the employee received payments in good faith through official channels with no individual notice of error, can trigger wage protection claims that wouldn't apply under a more reasonable recovery approach. By pushing too hard and too fast, the employer may have created exactly the kind of dispute that makes their position harder to defend in front of a judge. What do you think the right outcome is here? Let me know in the comments. So what's the most likely real-world outcome? Marcus almost certainly has a legal obligation to repay something. Unjust enrichment is a recognized doctrine and Illinois courts do enforce it. But you owe us money and you owe us all of it. Right now, on our terms alone are entirely different propositions. A realistic settlement. Full principal repayment acknowledged in principle, spread across 12 to 18 months of modest paycheck deductions, paired with a separate written acknowledgement of Marcus's additional responsibilities and a concrete path to formal compensation adjustment. That is not an unrealistic outcome. It is what a competent employment attorney would pursue. Marcus mentioned quitting. That instinct deserves a direct answer. Resignation does not eliminate the debt. An employer can pursue civil recovery regardless of whether the employee still works there. But quitting before settlement is reached removes Marcus's most significant ongoing leverage. His continued productivity, his institutional knowledge, and the company's practical reluctance to lose a performing employee over a mistake they created. The smarter move is to negotiate from within the employment relationship, reach a settlement that works, and then make the decision about the future from a position of resolution, not desperation. There's a dimension worth naming that rarely gets discussed in these situations. The employee the bonus code was originally intended for presumably didn't receive it for 14 months. That person may have a separate grievance against the company. The payroll administrator who made the original entry may face internal consequences. The HR and accounting departments that processed 14 months of payroll without flagging the discrepancy bear institutional responsibility for the loss. Marcus is one node in a much larger systemic failure. The company's own legal team almost certainly knows this, and it affects how aggressively they'll push. The core legal reality, stated plainly, Marcus will likely repay some or all of the principal. Illinois courts are not going to tell a corporation it has no claim to money paid in error. But the amount recovered, the timeline imposed, and the conditions attached are all subject to negotiation, mediation, and, if it comes to it, judicial equitable review. Marcus's goal is not to escape responsibility entirely. It is to rebalance a power dynamic that the company's own 14 months of negligence created. That is not just ethically reasonable. Under Illinois law, it is legally supportable. Cases like this leave behind lessons that extend far beyond the dollar amount. That vague compensation adjustment comment from the manager, one follow-up email, written that same afternoon, would have changed the entire trajectory of this case. Not because Marcus did anything wrong, but because in employment disputes, memory fades and documentation is evidence. The most protective thing any employee can do after any verbal compensation discussion is send a simple confirmation email. Following up on our conversation today regarding a compensation adjustment, please let me know the timeline for formalizing this. 5 sentences. Potentially $8,700 in legal protection. The broader lesson for employers is equally stark. Payroll errors of this scale, recurring, undetected across an entire calendar year, touching multiple approval layers, represent a systemic internal control failure. Courts don't always penalize that failure directly, but they factor it heavily into the equities of recovery. A company demanding aggressive full repayment from an employee who relied in good faith on their own verified payroll systems faces real judicial headwinds. Internal controls and audit processes aren't just accounting hygiene. In situations like this one, they become the legal foundation or the liability of everything that follows. If you are ever handed a legal document under pressure, a repayment agreement, a settlement offer, a release of claims, the first step is always the same. Do not sign anything until you understand exactly what you are giving up. Links to Illinois wage claim resources and a free employment rights checklist are in the description below. And if this case resonated with you, our next video covers a similar dispute where the employee pushed back, the case went to a judge, and the outcome surprised everyone in the courtroom, including the company's own attorneys. Subscribe so you don't miss it.